Welcome back to Good Law, Bad Law. On today's episode, my guest is Phil Gregory. He is co-lead counsel to 21 youth plaintiffs in what has sometimes been described as the biggest lawsuit on earth. It's 21 young people who have challenged the United States government for decades-long policies of the federal government in support of the fossil fuel industry that has substantially contributed to our climate crisis. The Ninth Circuit, one of the most important federal appeals courts in the country, just last week came down with a very important opinion. On one level, not so great for the case, but on some other really important ways, historic in terms of what the court has found in favor of these plaintiffs and the claims that they've been making in court. And the battle is not over. It's just getting started in some important ways. I walked through all of these issues with Phil. It's a fascinating, important conversation. If you've been paying attention and noticed that young people are taking to the streets on the issue of climate change, then you need to take notice of this as well. I hope you'll enjoy this episode. It has been called the greatest, biggest lawsuit in the world. 21 young people challenging the United States government and its decades-long practices with regard to climate change. There was a very important decision in the United States Court of Appeals for the Ninth Circuit last week. And on today's episode, my guest, Philip Gregory, co-lead counsel for the 21 young people who brought this historic case, is joining me on the program to discuss what has happened and what steps lie ahead. Phil Gregory, Philip, thank you so much for being on Good Law, Bad Law. I really appreciate it.
Thank you so much for inviting me.
We had about a year and a half ago, we had Kelsey and Julia on the program to talk about the lawsuit, but an awful lot has changed since then. And an unfortunate, but maybe not completely unfortunate decision from the Court of Appeals last week came down. And I think it's important to revisit this and understand what has happened and what you and the plaintiffs in this action are going to do about it. So as co-lead counsel in this important case, Phil, can you bring us up to date on how the Ninth Circuit ruled and why they decided that the case could not proceed?
Sure, and I think the best place to start is in the district court, because you want to know what the procedural posture was of the case when the Ninth Circuit issued its opinion. What happened in the district court is our judge, Judge Ann Aiken, when she set the trial date back in 2018, bifurcated the case. So there was going to be a liability phase and a remedy phase. Then in the summer of 2018, the federal government moved for summary judgment. And we responded with the evidence that existed as of June and July 2018. However, discovery went on for several more months. And then when Judge Aiken issued her opinion on October 15, 2018, she reaffirmed that the plaintiffs had standing, meaning the plaintiffs had showed they were being injured. The injury was traceable to the conduct of the defendants, and the court could issue an order redressing the plaintiff's injuries. Through various procedural machinations that I won't spend time with because they can get confusing.
Yeah.
Ultimately, Judge Aiken certified that order as well as her earlier order on two motions to dismiss that had been issued on November 10, 2016, certified those for appeal to the Ninth Circuit. And then on December 26, 2018, the Ninth Circuit agreed to certification of this interlocutory appeal. The case was briefed, and then on June 4, 2019, it was argued. What's very important for those who read the decision is that after oral argument, the United States Supreme Court decided a political gerrymandering case called Rucho versus Common Cause, which was decided by the Supreme Court essentially 3 weeks after oral argument.
This was the North Carolina gerrymandering case?
Exactly, North Carolina, and then there was a related Maryland case.
Right.
North Carolina, what the Democrats were complaining, Maryland, the Republicans were complaining. And but the Supreme Court decided that case. What the Ninth Circuit panel didn't do in our case is request further briefing or oral argument on the Rucho case. And then, as you correctly pointed out, last Friday, January 17, 2020, two of the judges decided that an Article III court cannot provide the plaintiff's redress for purposes of standing, relying primarily on the Rucho decision.
I see.
That essentially some, what I'm going to generally call some disputes simply are beyond the constitutional power of Article III courts.
Article III meaning federal trial courts and appeals courts.
Exactly.
Well, let's pause then before we get into some of the details of what the Ninth Circuit said in this opinion from Friday. Let me just pause and go back over some of what you've said to make sure I understand. Because this can sound very procedural and technical, and as you use the word machinations, it might sound that way to people, but these are really fundamental questions about how really big, complex, and important issues get resolved and where they get resolved and who has the authority under the Constitution to resolve them. So let's just take a step back. So we've got 21 young citizens of the United States who bring this huge case claiming that the federal government not only has known for decades about the dangers of climate change and the role of the fossil fuel industry in contributing substantially to climate change, but that the federal government actually participated actively, not merely through its inaction, but actively participated in promoting the fossil fuel industry to the detriment of our planet, so to speak, because over these decades we've seen substantial advancing of global warming and climate change. So that's the what you've called the liability part of the case, the wrongful conduct part of the case. Is that right?
Absolutely. You've got it. You've done a really good job summarizing that part of the case, that what these 21 youth are complaining about is not that the federal government has sat back and done nothing. It's, in essence, an inaction issue.
Right.
No, this is a case where these youth have presented substantial evidence that the federal government is a substantial factor in causing the climate crisis as a result of federal government conduct.
And here's I said this in my intro, what I wonder, and I am going to put this to you as we work our way through these things, but I wonder whether there are ways in which this decision, which ultimately results in, for the time being, the dismissal of this case, nonetheless can be seen in many regards as a victory. And I'm quoting, I read the opinion today from the Ninth Circuit. As you said, 2 of the 3 federal appeals court judges ruled in favor of dismissing the case. But the majority, these 2 judges who ruled in favor of dismissing the case, nonetheless, in their opinion, wrote that there was copious expert evidence provided by the plaintiffs of rising carbon levels in the atmosphere that has led to global warming. The majority notes that the hottest years on record all fall within this decade, and each year since 1997 has been hotter than the previous average. In the next paragraph, they go on to say, the record, meaning the record that you were able to show in this case before this court, the record also conclusively establishes that the federal government has long understood the risks of fossil fuel use and increasing carbon dioxide emissions. And then the next paragraph says the record also establishes that the government's contribution to climate change is not simply a result of inaction, which is what we were just talking about. The government affirmatively promotes fossil fuel use in a host of ways, including beneficial tax provisions, permits for imports and exports, subsidies for domestic and overseas projects, and leases for fuel extraction on federal lands. These are remarkable findings of fact, if you will, to say that they are conclusively demonstrated. Am I wrong in finding this extraordinary that a hugely important federal appeals court has made these findings of the government's role in causing climate change?
You're not only not wrong, but the amazing thing about the record, both before the trial court or the district court and the Ninth Circuit Court of Appeals, is the overwhelming evidence, both by admissions from the federal government in its answer to our complaint, as well as statements, reports, memos from the federal government that clearly confirm that the United States has known that right around, based on projections, that right around this time frame, right around 2020, essentially, as Kurt Vonnegut once put it, the excrement would hit the air conditioning, and they've known that the youngest generations would be the ones to bear the biggest burden in terms of climate change, but in applying a discount rate, said that economically we're going to continue to put the foot on the accelerator, essentially choosing to have a better gross national product than to have a better climate.
Yeah. Well, and Phil, the other really extraordinary thing about what the appeals court found here, before we get to the final issue that the court ultimately decides is the basis for dismissing the case, we've seen a really meteoric rise in the participation of young people taking to the streets, striking, protesting in the streets on the issue of the role of the fossil fuel industry in our politics and the role of the fossil fuel industry in substantially contributing to global warming. I might also put a personal plug in for my own daughter, my middle daughter, Olivia, who right now is in New Hampshire canvassing on the issue of climate change. She works for, she's a full-time student, but she's taking time off on behalf of the Sunrise Movement and joins thousands and thousands of children. She's 20, so she's not exactly a child, of young people, literally around the globe. I mean, Greta Thunberg is the Times Person of the Year this year. And here the 21 youth who brought this case, starting all the way back in, was it 2015 when this lawsuit was begun?
Yes, yes, August 2015, suing the Obama administration.
Right, it was originally a case against the Obama administration, and remarkably, though not without basis, I think with plenty of basis, but nonetheless remarkably, I think, this court also finds substantial basis for the 21 plaintiffs in this case demonstrating real injuries on account of the policies of the United States government in terms of climate change, because that's also a necessary ingredient to any citizen bringing a claim against any party. You have to have suffered an injury. You have to have suffered some harm. And the court finds that there is substantial basis for the plaintiffs demonstrating all kinds of different harms that they raise. I mean, what are some of the types of harms that the youth plaintiffs in this action are claiming?
So we have plaintiffs from all across the country, from Alaska to Florida, Hawaii, Oregon, where the case is venued. But we have, for example, our plaintiff in Florida lives on a barrier island and is already experiencing sea level rise, Levi. And we have other plaintiffs, for example, Jamie, whose tribal issues have caused her family to move because of drought. There's numerous issues each of these plaintiffs have faced that are not just what I'm going to call psychological injuries, although we do have clear evidence of that. But there's other injuries that these plaintiffs have suffered, and as a result of suffering these injuries, the Ninth Circuit found, as you correctly note, that the first prong of standing, injury in fact, has clearly been met.
And the basis of these 21 young people being able to sue the federal government is that they're claiming that they have a right to sue under the United States Constitution, under the Due Process Clause of I take it under the 5th and 14th Amendments. Why is this a constitutional claim that they're bringing?
Well, sure. There's several bases for that. One is obviously the district court, Judge Aiken, recognized that United States citizens have a constitutional right to a climate that sustains human life. And what it means to have a constitutional right is that the federal government can't do something that will drastically harm that right. And so we have another constitutional basis for our claim, which is called the state-created danger. Again, the federal government doesn't owe you a duty to protect you in the abstract, but the federal government does owe a duty to you if it has essentially caused the opportunity for, or had a role in causing the opportunity for you to be harmed.
Right.
The federal government has to take steps to prevent you from either being injured or suffering further injury.
Well, that's why this distinction between inaction versus affirmative action is so important, right? This isn't just a case of standing by.
So important.
Yeah.
Right. So, for example, there's a case out of the Ninth Circuit called Hernandez versus City of San Jose, a fascinating recent decision by the Ninth Circuit where during a rally of concerning then candidate Trump, a number of the Trump supporters were ushered by the police into a crowd of people who were essentially opposing and prepared to do harm to the people who were supporting President Trump. And the Ninth Circuit said that these those Trump supporters stated a claim for harm because the government was causing harm to American citizens. And that's what the Constitution protects.
Okay. So you've mentioned a few times that this case turns on a question of standing, which is something all law students are required to learn about in law school. But I think speaking for many of us who've been through that process, it is one of those things that you don't want to be called on to speak on in class because it's tough. It's complicated.
It's very complicated.
Right? I mean, you could do a whole course just on what is standing and what is not standing. So we know that that the court recognized here that the plaintiffs had shown sufficient evidence of wrongful conduct. Not that there's an ultimate determination on that, but certainly enough evidence to proceed to trial. And the plaintiffs had also demonstrated sufficient evidence of injury in fact, that they could claim injuries and had evidence to support that. But the case and the opinion that came down on Friday turned on this question of redressability. Does the Article 3 or do the federal courts have a constitutional authority to redress those injuries resulting from those harms? So how does the Ninth Circuit avoid this case by resting on the redressability issue?
Well, so the way the panel, the two-judge majority opinion deals with this is, will a decision by the trial court substantially redress the injuries, and is such a decision within the district court's power to award? And so but I want to make sure that your listeners are very clear. There hasn't been a trial in Juliana, and the district court hasn't had a chance to issue its opinion on what the appropriate remedy or what the appropriate court judgment will be. And so when the Ninth Circuit panel is considering the case in its opinion, it's considering what could a hypothetical judge award based on these injuries and the federal government's role in causing those injuries, both of which were established.
Yeah, it almost seems backwards, Phil. I mean, usually an appeals court is reviewing a decision of a trial court after that decision has been made. And I understand that certain issues were taken as a matter of an interlocutory appeal or an appeal before the end of the case. And that's how the Ninth Circuit gets their hands on these issues when they do. But as you point out, the trial court, the district court, didn't even get a chance to try to fashion a remedy. Didn't even try to give them a chance to do that. They simply took the appeal on that question before the trial court had even had a chance to attempt to fashion a remedy.
And if you read the district court's opinions on October 15 and in certifying this case on November 21, both in 2018, Judge Ann Aiken is very, very emphatic that she believes a trial of this case will help her frame the remedy and will allow her to determine what a court can do based on the scientific evidence. And so it's very important to understand that while the Ninth Circuit panel here said a court cannot issue a remedy or cannot redress the injuries, the district court was saying that given the complexity of this case, the scope of the harms, it's really necessary, and the uncontested scientific evidence, it's really important to have a trial here so that the court can spend time and try to understand the issues presented and to issue a decision that meets the constitutional justiciability standards.
And as I understand it, Phil, what the plaintiffs were asking for in terms of a remedy was that the court require the federal government to develop a plan to phase out fossil fuel emissions and to reduce excess levels of CO2 in the atmosphere. So, I mean, from the standpoint of the plaintiffs, why can't a court, I mean, the federal courts throughout history, throughout our country's history, tell government what to do in all kinds of complex situations. There have been enormously complex cases, for instance, involving prison reform, involving school desegregation, involving, a host of other things. I'm sure you can come up with other examples more quickly than I can. Well, the gerrymandering case that you mentioned, right? Here's a case that, gerrymandering is something that comes about when the political body, the legislatures, redraw voting districts in a way that is seen as unconstitutional or discriminatory, and courts have ordered the political branches, they did in that North Carolina case that you mentioned, to go in and fix it, to fix a gerrymandered system. So why, is it just a matter of degree? Is the Ninth Circuit here saying, oh my gosh, this is just so complex we can't do it, but in other cases we can?
Well, and you've hit on the core issue, but I want to reframe one thing.
Okay.
What we asked is it's three parts, but I think each part is important. The first part is we wanted to have the district court declare that there's a constitutional right and that right has been violated. Next, we wanted the district court to find some targets, like you mentioned the prison cases, or you mentioned the school desegregation cases, some sort of numerical standard which could be hit based on science. And then, and this is very important for your listeners to understand, then we ask the district court to order the federal government to come up with a plan that would hit those targets. So let me use a different fact pattern, but gets to the same result. You brought up the prison cases. In the decision Brown versus Plata, the underlying court found that the California prison system was over 200% overcrowded, such that prisoners weren't getting meals, medical attention, etc. And the district court set a target, 137.5% overcrowded. That's what the California prison system could be, and ordered the prison system to come up with a plan to hit that target.
I mean, that sounds perfectly analogous.
Itself, yeah, the district court itself didn't come up with the plan. It ordered the prison system to come up with the plan, and the United States Supreme Court affirmed that decision. Brown versus Plata is the United States Supreme Court decision affirming this idea of the district court coming up with a target. Same thing occurred in the school desegregation cases, and then ordering the relevant governmental body to come up with a plan to hit that target based on the expert evidence. And that's exactly what we were asking the district court to order here.
Well, I think we have to give some credit to the third judge on the panel. Judge, is it Staten or Staten?
Staten.
Judge Staten wrote a dissenting opinion, really taking the other two judges to task for really sort of punting on this. And I'm looking. Oh, here. I like this line from her dissenting opinion. She says the majority, referring to the two judges who voted in favor of dismissing the case, the majority laments that it cannot step into the shoes of the political branches, meaning the legislative branches or the executive branch, but appears ready to yield if those branches walk the nation over a cliff. So she's got pretty harsh language and would have, I take it, allowed the case to go back to the district court to address the issue of a remedy. So, I mean, where do you go from here now? I mean, is this? Do you take further appeal to the entire Ninth Circuit, which is made up of many more than just the 3 judges who decided this case as a panel, or do you go to the Supreme Court from here? What is the next move, do you think?
So what occurs in the posture we're in, and what we believe we're going to do, is you file, it's not technically not an appeal, you file a document called a petition where you ask, in essence, the full Ninth Circuit to rehear or re-examine this case. And so then if the Ninth Circuit agrees to do that, and it doesn't have to do that, but if the Ninth Circuit agrees to do that, then there would be a panel of 10 Ninth Circuit judges plus the chief judge that would consider whether or not to rehear and, in essence, issue a new decision on this case. So that's the next step, and we hope to do that certainly within the next several weeks, to file such a petition with the Ninth Circuit and ask them to reconsider the issue of redressability, whether the federal court can issue an order based on the facts and scientific evidence in this case. Got
it. Fantastic. Well, I've been following this case very closely. As I mentioned, we had the lead plaintiff, Ms. Juliana, and your colleague, co-counsel on the program. Has to be over a year and a half ago at this point, and I've been following it very closely ever since. I think it's an extremely important litigation. It's obviously it's a extremely important issue, and I want to thank you very much, Phil, for being on the program to walk us through this. I encourage everybody to read this opinion. We'll post it or a link to it as part of the description of this episode, which we will put up right away. Appreciate. Normally we post episodes on Friday. We're going to get this up immediately so that people have access to the latest on what's been happening. Fascinating set of issues, very well explained. A lot of this is very tough civil procedure-y kind of stuff, but at the same time extremely important for citizens, all citizens, to know that there must be ways to take their government to task in a situation like that, like this, and to know that they have access to the courts for relief in these kinds of cases. So I wish you well and good luck, and please know that we'll be following along closely here. And again, thank you, Phil, very much for being on Good Law, Bad Law. I appreciate it.
And thank you, Aaron. And I want to reach out to your daughter and make one final point. It's ironic that this case being brought by the youth of America who can't vote, we're told by this court, well, the only remedy you have is in the voting booth.
That's so true.
And to me, that's a hollow remedy, given the realities of this situation.
That is a fantastic point. Very true. And I will pass that on to her as well. I'll be talking to her this afternoon. So thank you again, Phil. Philip Gregory, co-lead counsel in the Juliana versus the United States case. Again, such an important, groundbreaking. I am so impressed by this opinion. It's obviously disappointing, the ultimate result, but at the same time, to have such an important court make such clear and profound determinations about the role of the government in climate change, I think in itself is a tremendous victory. So I wish you well with the rest of the case, and we will be watching very closely.
Thank you, Aaron.